Hi, good afternoon, everyone. Thank you all so very much for joining us. As people come in, please feel free to come and sit up front. We promise we don't bite. Thank you all for joining us for this important conversation. There's a lot going on in the vaccine space, and one of the biggest potential programs that many of you may have not know much about. So we're glad you're here to join us today, but it's the Vaccine Injury Compensation Program, or VICP. And it has a huge role in protecting vaccine access and affordability, protecting public health, and also providing remedies for injured parties. I'm Candace DeMatteis. I'm the Vice President of Policy and Advocacy for the Partnership to Fight Infectious Disease, and we're so thrilled to be hosting this wonderful expert panel to discuss these issues. Vaccines are one of the most effective, well-studied, and safe public health tools that man has come up with. But like any other medical intervention, there are risks associated with it. The VICP acknowledges that reality and is designed to provide people with vaccine-related injuries with compensation, while at the same time providing the stability needed for us to continue to have access to vaccines at an affordable level, but also to inspire more vaccine innovation that helps to keep us safe. The VICP is one of the most important, but perhaps one of the more least understood public health programs that the federal government operates today. There's also a fair amount of disinformation about that mischaracterizes the program that's circulating, and that could ultimately lead to harmful policy decisions. So we want to clear up some of those misconceptions today and then provide some opportunities for ways to enhance the program as well. Over nearly 40 years, the program has compensated thousands of individuals and families while at the same time helping to sustain a stable vaccine marketplace that protects millions of Americans from vaccine-preventable illnesses. Today, the program does face some policy challenges, both legislative and administrative. Some reform efforts are focused on enhancing the program and addressing bottlenecks that slow the process and impede compensation. Others have emerged that would fundamentally alter how the VICP operates, including efforts to expand eligibility, perhaps beyond the scientific evidence, and weaken independent expert feedback and review of the program. These discussions raise important questions for policymakers, and given the potential impact on vaccine access and affordability to all of us as members of the public. Today, we'll ask different questions of our expert panelists, get some background on why Congress created the VICP and what problems it was designed to address, how the program balances compensation with vaccine access and affordability, how it balances compensation for injured parties, not vaccine compensation, with access and affordability, what proposed policy changes could mean to the future of the program, and what policymakers should keep in mind and consider as they evaluate different potential reforms to the longstanding bipartisan framework. We're fortunate today to be joined by distinguished experts who bring experience from medicine, policy, patient advocacy, law, and public health to help explore these issues. So I have the pleasure of introducing our panelists. I'm going to start with Lynn, who's right here beside me. Lynn Albizo is the Chief Public Policy Officer for the Immune Deficiency Foundation. After beginning her career practicing disability law in Maryland, Lynn transitioned to working as a legislative advocate on healthcare policy, focusing on mental health and disabilities. She joined IDIF in 2016 and currently leads the public policy team advocating for improved healthcare access before decision makers at the state level, at the federal level, and before private insurance companies. Lynn spends a great deal of time right here on Capitol Hill. Many of you may recognize her. Educating legislators on issues related to access to treatments, research, telehealth, and newborn screening. Lynn also leads the Immunocompromised Collaborative, representing patient groups impacted by being immunocompromised. Thank you, Lynn, for joining us.
Thank you.
Dr. Mike Burgess. Prior to being entrusted with representing the people of the 26th District of Texas in the House of Representatives, former Congressman Mike Burgess practiced medicine as an obstetrician for 30 years. Dr. Burgess served on the House Energy and Commerce Committee as the chairman of the Subcommittee on Commerce, Manufacturing, and Trade. In addition to sitting on the Subcommittee on Health and the Subcommittee on Oversight and Investigations, Dr. Burgess also founded and co-chaired the Congressional Health Caucus and was a leader of the influential Doc Caucus as well. His medical background and expertise provides a unique perspective on health policy and legislation affecting healthcare. Dr. Burgess's commitment to protecting patients' rights and raising the bar for the standard of care can be seen in his efforts to expand care options for patients, to sensibly reform liability laws, to protect patients' rights, and to ensure that we are educating enough doctors to provide proper care for civilians and veterans alike. Thank you so much, Dr. Burgess. Next, Renee Gentry. Renee is a founding member of the Vaccine Injured Petitioners Bar Association and served as its president for 4 years. After 19 years in her former firm, Ms. Gentry founded her own firm, the Law Office of Renee J. Gentry, Esquire, in Washington, D.C. in June of 2019. She has specialized in vaccine injury litigation for 25 years. In addition, she is the director of the Vaccine Injury Litigation Clinic at the George Washington Law School here in D.C. She is one of the leading experts on vaccine injury litigation in the National Vaccine Injury Compensation Program, or VICP. She is co-chair of the vaccine litigation practice of the American Association for Justice. She has also advised numerous congressional members, staff, and committee on issues related to VICP, and has also helped to draft proposed legislation. In March 2024, Ms. Gentry testified before Congress and House Committee on Government Oversight Select Subcommittee on the Coronavirus Pandemic, hearing on the need for modernization of the VICP. She's licensed to practice law in the District of Columbia and is admitted to the U.S. Court of Federal Claims Bar, the U.S. Court of Appeals for the Federal Circuit Bar, and the U.S. Court of Appeals for the D.C. Circuit Bar. Thank you so much for joining us, Renee. Last but certainly not least is Dick Kingham. He is senior counsel in the law firm of Covington and Burling, with extensive experience in food and drug regulation. For more than 50 years, he has advised most of the major innovative pharmaceutical manufacturers and biotech companies, as well as the principal industry trade associations. He has served as a member of the committees and expert panels on the National Academies of Medicine and the Statutory Advisory Council of the National Institute of Allergy and Infectious Diseases. He's also taught food and drug law at the University of Virginia School of Law and the Georgetown University Law Center. He has also served as a member of working groups formed by non-governmental organizations on reform of pharmaceutical regulation in India and China, as well as a committee that developed recommendations to expedite development of new drugs and vaccines for diseases endemic in Africa. He also has deep experience in compensation and liability issues related to vaccine injuries. He represented vaccine manufacturers in contract negotiations and liability legislation during the 1976 swine flu episode, and helped draft and negotiate the National Childhood Vaccine Injury Act of 1986, which is that is the law that created the Vaccine Injury Compensation Program. He also helped to negotiate the liability and compensation provisions of the Public Health Readiness and Emergency Preparedness Act, or PrEP Act, in 2005, and provided advice during the COVID-19 pandemic on the establishment of no-fault compensation programs in numerous low and middle-income countries. So I think you will join me in agreeing that this is an amazing panel, and any questions you have about VICP or the importance of vaccines, this is the group to answer those questions. So I'm going to kick us off just with a general question for all of you. The National Vaccine Injury Compensation Program was designed to really serve two purposes. One, compensating individuals who experience vaccine-related injuries. And the second, maintaining access to vaccines to prevent illness and outbreaks. From your perspective, I would love to hear how well the program is fulfilling those purposes. Dick, do you mind if we start with you?
Sure. Well, first of all, I don't have real statistics, but I have a lot of anecdotal information from the perspective of manufacturers. One thing that was clear back in the 1970s and early 80s when the events occurred that led up to the enactment of the 86 legislation was that vaccines were not one of the popular things for drug companies to invest in. A liability was one significant risk, but also they were relatively low profit products compared to other drugs and that sort of thing. What I observed in a practice where I represent clients that are developing new drugs was that in the years following the enactment of legislation, there's a resurgence of interest in developing vaccines, and a huge number of vaccines have been developed since then until the present time. I'm also clear from talking to especially venture capital firms that invest in different portfolios of drug and vaccine development that vaccine development is not a popular investment at the present time, for obvious reasons, because liability risks may exist that haven't previously existed, but also the standards for developing the products may change, and in fact the ground shifts and people don't know where they are at any given time. So what I would say is that from the point of view of liability and compensation and so forth, the importance of the VICP is tremendous. If we want to have a healthy industry developing new vaccine products for the future and developing new platforms for vaccine products.
Thank you. How about you, Renee? From your perspective, is it?
I would agree with Dick in that it's been very successful in the development of new vaccines. We started with 6, covered vaccines. It's developed vaccines that are not covered in our program as well. Our vaccines are basically the childhood vaccination schedule that are covered. We started with 6, we're at 16. It's also been very successful in compensating vaccine-injured individuals. Up until recently, very little, I would say a handful of vaccine-injured petitioners that filed claims opted out to pursue civil litigation. That did change with the Gardasil opt-outs, but that is an aberration. That is not a unique or not a usual thing. That is the first time it's ever happened. And I think it happened for a very specific set of circumstances. It is also because it is a lower burden to proof, you don't have to demonstrate fault. And we do have a table injury section, which gives you a presumption of causation. It has made it much easier for those individuals alleging a vaccine injury to receive compensation rather than going out into civil litigation, which is remarkably difficult. And following the Supreme Court decision in Brucewitz, it made it even more difficult to be successful in civil litigation. So I think from those standpoints, it's been very successful. And from our Bar Association's position, it is the best scenario. For all of its challenges, it is still the best scenario for vaccine-injured individuals to receive compensation.
Thank you. Dr. Burgess?
Well, first off, Candace, thank you for asking me to be part of this panel. One of these things is not like the other. I'm not a lawyer, but I was also in Congress. So can I just ask for a show of hands of people who are here today who are actually working in a congressional office, who are helping your members? So God bless you. You are so important. Look, Congress is a funny world. Every day the urgent drives out the important, and it is up to you, the congressional staffers, to get in all of this information and then deliver it to your member in an understandable fashion. And you're going to hear today a variety of opinions, but one of the things I hope that you take away from this is vaccine preventable diseases are just that. They are vaccine preventable diseases, and it is good that we don't have to deal with those diseases any longer. I practiced medicine for more years than I care to remember. Did I ever see a case of tetanus? No, I don't. But I don't ever want to see one because it is so dreadful that you never want to be at the bedside of someone suffering with that. I've seen one case of diphtheria. One case of diphtheria to me for a career was more than enough. I don't need to go back there. Just to touch on some of the things that Dick and others have pointed out, our system, of course, capital intensive activities, I'm a believer, I'm a supporter of a capitalist system, but I will also tell you one of the things I've learned over the years. You can say a lot of things about capital, but it is not courageous. And if you make it hostile, capital will find somewhere else to go. They'll go invest in SpaceX. There'll be other places than helping develop the vaccines that will prevent diseases for the next generations of Americans to come.
Thank you. Lynn, how about from the patient perspective?
Sure. I think I have a very unique point of view. We represent the group of people that are immunocompromised. People with primary immunodeficiencies, which is our core group, are individuals that are born with an immune system that does not work properly. And then I also lead the immunocompromised collaborative. So those are different patient groups that are uniquely immunocompromised. So people that have had with autoimmune disorders, that have had organ transplants, different cancers, of course, HIV/AIDS, all different people who, are very vulnerable. And in our community, there are individuals who cannot be vaccinated because they don't have immunity. But that is why it's so important that the people around them are all vaccinated in terms of, to protect them, because they basically need that protection by having everybody around them vaccinated. We care about the program for both making sure that people are adequately compensated that are injured. And we actually have in our community was the individual, one of the last people to ever get polio because he was immune compromised. He had a primary immunodeficiency, so he didn't build up immunity. And so that was a valid injury. And because of his work, now you don't have live vaccines, right? So, which is great. We figured out that, we don't want to expose those people. But again, that means that they can't be vaccinated. So children born with certain primary immunodeficiencies cannot get the measles vaccine, cannot get these other vaccinations. So they need that protection. So we want to make sure that vaccine production is viable and thriving, and we want to make sure that they're not, that the people who are truly injured are able to be compensated, and that the program is robust and continues.
Thank you, Lynn. Dick, you talked a little bit, I talked a little bit from your bio about actually being a part of the negotiations that took place that led to this. Can you give us a little bit more background on how that was? I understand it was bipartisan.
Sure.
I'm sure it was smooth sailing all the way through, just like today, but would love to get some more background.
Okay. Well, sure. Well, the background really goes back maybe at least 10 years before 1986, when a number of things happened in the vaccine industry world and the world of vaccines medicinally. First of all, we had the swine flu episode in 1976, which turned out to be a fiasco. There was no pandemic. There were relatively few people who had, let's say, serious conditions. But when the vaccine was used on large numbers of people, it turned out that a condition called Guillain-Barré syndrome was recognized. And so there were significant liability issues. Leading up to that, the manufacturers, which had all agreed, there were 4 of them at the time, to make enough flu vaccine for every person in the United States, were informed by their insurance companies that their policies would not cover that vaccine. And in those days, companies actually had insurance. They don't have it anymore, but they had it then. You can imagine what the boards of directors of pharmaceutical companies considered when they might be liable for injuries that emerge in a population of 200 or more million people. And so ultimately a resolution was reached, but it was a sort of short and sweet resolution that couldn't clearly be used in the future. The decision was that injury actions could only be brought against the United States government under modified visions of the Tort Claims Act, and that the manufacturers in supplying the vaccines would receive essentially no profits. They would make the products at cost. Now that solved the problem in the day. The companies were able to absorb that on a one-time basis, but obviously you can't go forward telling people that you got to give us free vaccines to avoid liability. And so there began a series of discussions that got more and more important as the liability situation changed. And there were a couple of things that changed it. First of all, 2 federal circuit courts decided that for the oral polio vaccine, there was a requirement that the manufacturer warn directly to patients receiving the vaccine about any risks of the product. But that was factually impossible because most of these inoculations were done on a mass immunization basis, and the immunization agencies, the public health agencies, were responsible for giving whatever information was used, and the manufacturers couldn't control it. And actually, the judges acknowledged that themselves. One, John Minor Wisdom in the Fifth Circuit said, in effect, in a footnote, "We recognize this isn't very fair, but somebody's got to pay." Well, obviously, that worried people. It only applied to oral polio vaccines, but at the same time, people were concerned that it could be expanded to others. And the same manufacturer which made the oral polio vaccine also had a spate of lawsuits relating to the pertussis vaccine. So it was basically dealing with a situation of immense potential liability and, frankly, diminishing profits as it had to absorb the costs of litigation, not necessarily losing cases, but having to litigate them and so forth. So we had that. With all those 3 things together, in 1985, the Institute of Medicine was commissioned to make a report on the availability of new vaccines and essentially the health of the vaccine industry in the United States. And it issued a comprehensive report which made clear that there was a serious risk that there could be supply problems for vaccines in the near future. Actually, for most of the vaccines, there was only one manufacturer. So even if it was just a manufacturing problem, it might be possible in 1 year not to have any vaccine. But in addition to that, of course, it was unclear how much longer companies could stay in the market with extraordinary liability concerns and still being paid essentially commodity prices. A number of people began talking to each other about this beginning in the early and mid-1980s. The American Academy of Pediatricians actually was one of the leaders, but of course the manufacturers were involved as well. And eventually, a bill emerged from Senator Paula Hawkins of Florida, but it was only one-sided. It created a compensation system, but it did nothing about the liability risks. That spurred manufacturers to start working in earnest with the other relevant constituencies to find a solution. And that meant really lengthy discussions with parents of children who had been or were alleged to have been damaged by the pertussis vaccine, and also indirectly, therefore, dealing with plaintiffs' lawyers who were advising them. At the same time, the industry was working very closely with the Academy of Pediatrics. We eventually developed a set of legislative proposals that all of those constituencies agreed with. So essentially, we were getting the agreement of the plaintiffs' lawyers who represented the parents of children who were injured. We had the agreement of pediatricians who were obviously concerned about the availability of vaccines and the willingness of people to take them. And of course, we had satisfied the requirements for the manufacturers. But the big hurdle that we faced was a member of Congress who was clearly the person we had to satisfy if the legislation was going to go anywhere, and that was Henry Waxman from California, who at that point was the key official in the House of Representatives with respect to health legislation. Henry Waxman is a brilliant person. He was a very effective congressman, whatever your views were of his specific policies, and he had a very smart staff. He was very much pro-plaintiff and against defendants in the pharmaceutical industry. So we had to satisfy somebody who was a tough customer, and we did. We ended up with a piece of legislation that is a compromise. It's not perfect from anybody's point of view, but it's pretty good, and it's worked for a long time. President Reagan had concerns. Now, whether they were his personally or they came from the Justice Department has never been clear to me. But at one point, he was suggesting that he would pocket veto the legislation if it wasn't changed in certain respects. That had to do mostly with a constitutional issue concerning the fact that federal courts were going to be hearing proceedings that weren't really adversarial in nature. We got Charles Allen Wright, who was then the greatest scholar of the federal court system, to write a letter explaining that that was not right. And in the end, of course, we didn't use the district courts anyway. We used the Court of Federal Claims as the venue. And on that basis, President Reagan signed it. So I'd say, and of course, Orrin Hatch went along with it in the Senate. That was key as well. And putting all of that together, we ended up with what I think was a solid and effective bill, and definitely one that, while being a compromise, had the ability to and did achieve the results that we hoped, which was that manufacturers would develop new vaccines and invest in the development of existing vaccine manufacturing processes, and that the patients, the persons who were injured, would get compensation that would be fair, would be received on a reasonably fast system, and that ultimately would not have to bear attorney's fees because they would be paid separately out of the system. And the whole system, this is something that was very clear Reagan would only accept, the whole system would not come out of appropriations, but would be from a trust fund that resulted from an excise tax that lived in its own little world. So when you put that all together, it is genuinely bipartisan. Some people who were usually very tough on one side or the other got together and agreed what to do. And I think what we've ended up with is pretty good.
Thank you for that background. That's super helpful. Renee, I'd love to turn to you to find out a little bit more about how the process works in practice. And you also mentioned something about opting out of the system. So I'd love to hear, because there are claims that the VICP means you lose your right to a trial. So I'd love to hear you talk about that a little bit too.
Sure. I think one of the most important things you can say when talking about vaccines and vaccine injury and litigation is words matter. And to start with that, being vaccine injured is not the same as anti-vax. And we live in a 140 character world, and vaccines need all of the words that we can get. So as I said to some people earlier, I always like to say that I like to be the thermostat and not the temperature when it comes to vaccines. I am thrilled to know that the DOJ has always been a problem. And I assure you that it is adversarial. I would assure President Reagan that it is an adversarial process. It's a legal process. Overall, the Vaccine Injury Compensation Program is a really remarkable compromise. And I come from the generation where compromise was not a bad word. It's actually how you accomplish things. And one of the most important things is, yes, you can opt out. You still have the right to sue civilly. That's what maintains the program's constitutionality. We like to use that word a lot in the law. Constitutionality, it's important to make sure that the program survives. Its success on the one side that we said earlier about the development of new vaccines has caused a challenge with the the slow rolling of Congress. Anytime you have to go back and get something done at Congress, the statute says that we can have no more than 8 special masters. That's our version of judges in the Court of Federal Claims. It is now 2026. We have 16 vaccines and we have 8 special masters. So we now have approximately 4,500 cases at any given time. And with the addition of the flu shot, the HPV vaccine, and one other, and table injuries, we've seen a tripling of filings in those cases. Not because vaccines are any less safe, but because more people have the ability to file suit. More people, the program opened up to more people, right? When you also have something like the flu vaccine, which is everyone every year, as opposed to childhood vaccinations, one group of people for a short period of time. The main challenges of the program today are delay and a lack of modernization. Juliana's here has been working very hard to try to get some modernization language through, one being the special masters. We need increased special masters because the delay in non-table cases are now taking approximately the same amount of time as civil litigation. The language in the statute was originally 240 days. You could opt out, well, it still is 240 days. You could opt out of the program if the special master has not reached a resolution in 240 days after filing. To be clear, that number was never hit. Anytime you have lawyers involved, it's going to slow things down a little bit, or trying to get medical records. Anyone that's ever tried to collect medical records knows the 7th circle of hell that is. So things get delayed, but that is something that can be adjusted. And the table cases, which go much more quickly, generally speaking, or they're intended to go much more quickly, can affect that. We need more special masters. Also, the compensation set in the program, you hear a lot of misleading information that your compensation in our program is capped at $250,000. That is not correct. Pain and suffering is capped at $250,000. Unlike many states where economic damages are capped through tort reform, our economic damages have no cap. I've settled an individual life care plan for $60 million in a case before. So there are substantial funds available because the goal was to help people with their medical care and take care of them. And the death benefit is still $250,000. So that's a little bit more challenging to put with petitioners, but legislation is working on bringing that up to date as well. Actually, I did that. One of the things that we do have a challenge with in our program, and I've heard a couple people mention it today, talking about when you add a vaccine or add an injury to the table, epidemiology, being grounded in science and epidemiology. So one thing to keep in mind is every vaccine that is on our table has been through safety studies, and all of those safety studies show that there is no increased risk of any particular injury, or the vaccine would not be on the market. So when we have a non-table case, meaning you don't have a presumption of causation and you have to go forward in more like a regular trial with experts, our burden of proof, we have been arguing, should not be epidemiological studies, because we will never have that. Because you don't want us to have that. If we have that, people are being unnecessarily harmed. The example of the rotavirus vaccine initially being introduced, when it was removed because the increased incidence of intussusception was approaching a relative risk of 1, when causation is at 2 and it gets pulled, that just shows we'll never have that. But it should be grounded in reasonableness. Another thing that happened that caused significant delays in our program was the tightening of the table and the removing of injuries, as well as the addition of vaccines without any table injuries. The example I used earlier, the Gardasil vaccine, is one of those. It was added to the table without any table injuries. That means every single case that went through as a full-blown case of litigation with experts, et cetera. Our program is still a fairly conservative program from the court's perspective. They don't like to say a lot of things cause injuries. A lot of vaccines cause injuries. They're very conservative in that regard. So we have to be very careful in the evidence that we submit. But to say that I guess the biggest misconception I would say is that our program can be used to either prove or disprove the safety of vaccines. It is not. It is a horrible tool for that. The only thing our program can be used for is to say whether or not this special master felt that this individual was injured by this vaccine in these circumstances. That is it. There's nothing else that can be drawn from that from a scientific or medical standpoint. From a policy standpoint, you should keep in mind that the table is actually not a medical scientific document. It's a policy document. So you add things in of what you choose to compensate and what we don't choose to compensate. And our position is always the more table injuries you have, the better it is, because things are going to move more quickly. You're going to not have as much litigation. You're going to reduce lawyer costs, attorney's fees, because you're not litigating out and things like that. And you get more things in. So one of the things we've been working with bio and pharma and everything is to actually add more table injuries. But again, it's all about how other people are interpreting that. And if they interpret it as C, it's more dangerous, then that's incorrect from our standpoint as well. The other thing I will say, the program, though, is still generally remarkably successful. We still are getting millions of dollars in compensation every year. There have been some reports that compensation has gone down. One of the reasons for that is because the majority of the cases in the program today are SERVA injuries, which is the shoulder injury related to vaccine administration. The average payout in a SERVA case is about $75,000. So that's why it looks like it, but the number of cases still going through are there. They're still getting compensated, just the injuries are not as significant that we're seeing being filed in it. The last thing that I would say that needs to happen in the process of the program is, one on the legislation standpoint is bringing the COVID vaccine over. I think we're in a real risk of dramatically increasing vaccine hesitancy if the COVID people are not brought over into our program from the countermeasures program. And I know a lot of really good people have been working really hard for a long time to do that, but I cannot stress that enough. The majority of the people that started in that fight and organizations were doctors and nurses that are incredibly pro-vaccine. that believe they were injured by the COVID vaccine, and they are now starting to turn into vaccine hesitant because when the next pandemic comes, will you get people to take a vaccine if these people are not compensated? And I think that's a significant thing. And we fight an uphill battle all of the time on the adversarial nature of our opposing counsel and how it's being challenged. And that in some of these circumstances, these cases are being dragged out even in table injuries. And that is a real thing. Challenging where that now certain table injuries are being fought as hard as non-table injuries. And that is a challenge for everyone, because when you drive up attorney's fees above the cost of the actual compensation, that becomes a challenge. And so one of the things we're always fighting is that. Overall, however, even looking at the recent settlement, this program is by far remains the best option for those with vaccine injuries. And it just needs to be updated. I think the infrastructure all around, HHS needs more people to do that. The Department of Justice has quite a few people now on their side, so we see their budgets too. To give you an idea, though, there's a little less than $5 billion in the fund that Dick talked about, the excise tax on the manufacturers that goes into the fund. The court's budget for the entirety of the program is $5 million. In the 40-plus year history of the program, we've never had to touch the principal of the fund to pay out any of the compensation. So when you hear people talk about we're going to bankrupt the fund if we add something, again, temperature, thermostat. Be down here. That's not accurate. We have there are challenges with it and bringing new vaccines in, like the COVID vaccine, but I think we can reasonably solve that with reasonable people.
Thank you. I appreciate that. Dr. Burgess, I want to turn to you. You heard Dick talk about the rising, concerns about lawsuits. You did a lot on liability reform as a member of Congress. Certainly know what that looks like in terms of provider shortages when it comes to OB-GYN services in particular. So I was curious from your perspective, why was it important that to meet that compromise in 1986? And then what are the lessons that could come to bear on some of the reforms that Renee and Dick were talking about?
Well, let me just quickly say I was not serving in Congress in 1986, but I was in practice. And the loss of the producers, I mean, we felt very acutely in the front lines, in the treatment rooms and the clinics. I will say that I have to agree. I mean, if you can somehow unbureaucratize HRSA, and this probably comes back on the legislative branch as far as increasing the number of special masters and making things work more to the benefit of the beneficiary. Yeah, those are things that's what Congress should be doing. That's one of the Article 1 provisions that we should embrace and willingly take on. And certainly the oversight function, I spent 20 years on the Subcommittee on Oversight and Investigations, Energy and Commerce. This is one of the areas where, I mean, all the other stuff that we busy ourselves with, this is one of the things where I think people would like to see us spend a little bit more time. We do have to remember that there is a difference between, and I am not a lawyer and I'm not even trying to play one, but there's a difference between federal law and state law. And when I came to Congress in 2002, 2003, one of my battle cries was I wanted to fix the medical justice system because we were being driven out of practice in Texas. We simply could not afford liability premiums any longer. Texas did enact a state law after that put caps on non-economic damages, similar to what California had done 25 years before then. And it had a very stabilizing effect on medical liability premiums, but that was at the state level, not at the federal level. And when I got up here, my governor, Rick Perry, at the time was quick to remind me, don't monkey with our state law because it's working. And if you guys try to fix it at the federal level, you're only going to make it worse. So those were words that I took to heart because I didn't want to get my governor mad at me. But it's an important concept. And the concept of this being a no-fault program, you don't have to prove someone was at fault. All you have to do is prove that someone was injured. deserving of compensation, and then for heaven's sakes, get them the money without a whole lot of trouble. One of the hearings that we had on medical liability reform early on in Energy and Commerce was from Michelle Mello. She writes a lot on the medical liability space, and her observation to me many, many years ago was, when you see one of these awards for big dollars in a medical malpractice case, it's not going to help that individual who was harmed. It's going to help the children of the siblings of that person, because it takes so long to get it through all of the different court appeals that it has to go through. So the beauty of this system is you don't have to do that. You can take care of someone who has a problem, and you can do it now. And that's what I think is the value of this. Yes, I worried that, and Dick, heaven help me, when we were talking about the swine flu, but that was an election year, right? 1976?
Yeah, it was.
And Gerald Ford made it a mandate that everyone had to take that god-awful swine flu vaccine that hurt so many people. When the flu vaccine ran out in 2004, that was an election year. So when you see, sometimes you see these things kind of pair up, and when you have one of these crises emerge in a presidential election year, it's quite possible you could get some bad policy on the other side. I'll just leave that for what it is.
Thank you for that forewarning, yeah. Lynn, I want to talk a little bit more about, we talk a lot about vaccine and being an individual choice and you're protecting yourself, but you talk about it, I'd love to hear more about how those choices affect the community, particularly people who cannot be vaccinated. And how important is that in terms of factoring into vaccine-related policies?
Absolutely. I mean, a lot of times, and I think that the elephant in the room right now is that I think we're in an era now where there is a lot of skepticism about vaccines. So I think we have to, I agree there needs to be reforms, but we have to be careful about a lot of the misinformation that's coming out being used in the wrong way, rather than, sort of improving the system, which we all want. For people who are immune compromised, you hear a lot about, you have a choice, and we should be free to not be vaccinated. Well, our community, they don't have a choice. If people around them are not vaccinated, then they can't fight infection, and they will get sick. And so when we see vaccination rates going down, it hurts people who, it hurts not only, people that are diagnosed with these different conditions, but also newborn babies, people who, and elderly people. I always talk about, there's basically about 72 million people that are immune compromised when you take the people that are, diagnosed with the conditions, plus you take people who are older, over 65, even if you look really healthy, your immune system starts to wane. So, and then you have newborn babies that haven't been vaccinated yet. So you're talking about 1 in 5 people. So that's your family, that's your small group. It's going to be, somebody's grandmother, your neighbor's newborn child, somebody with an autoimmune condition. All these things are, even if you're not looking at, large community public health issues, just think about your small circle. And when people make choices to not be vaccinated, their choice is impacting, people who are immune compromised. And so I think it's incumbent on government, not just, not necessarily saying mandates, but putting out messages and about the importance of vaccination and supporting vaccination. And right now we have a lot of mixed messages and also attacks on this program. All these things are putting our community at risk.
I did want to turn to our panel and just say, particularly for the staff here and others who are interested and engaged on this topic, one or two key things
Yeah.
that you'd love for people to walk away from today
Yeah.
with about the VICP or about vaccine policy generally.
Well, as I've been trying to emphasize, that it's very important to recognize that it's that there are vulnerable people that really are dependent on everybody getting vaccinated. And so, when you say it's your choice whether or not to be vaccinated, it's they don't have a choice. So it's really important to support all the systems that encourage everybody to be vaccinated and for there to be supply and encouragement of vaccination.
Dr. Burgess?
Well, I think one of the observations I frequently make is that we have been so successful with the prevention of vaccine preventable diseases that people forget what it means. And again, I go back to I think I saw one case of congenital rubella in my professional career, but that was one too many because that child was never going to get better. But it could have been prevented had his mother either been exposed to and had rubella prior to her pregnancy or had an immunization prior to the pregnancy. But once it happens, it's too late. And if, again, people forget those lessons of the past, we're going to see reoccurrences of illnesses that really haven't been around for a long time. And the difficulty there is we're probably, 2 generations past where people actually had to worry about that. Now, if you do something that damages the underpinnings of the system, the vaccine system as it exists, you are going to see recurrences. You're going to see recurrences of illnesses that have not been around in a long period of time. The measles is pointed to in West Texas, true enough. But at the same time, there's some much more dreadful actors out there. These are not benign conditions that we're talking about, and you don't want to invite them back into your lives.
Thank you, Renee.
I would go back to what I said earlier, which is that words matter. And we are living in extraordinary times, to be sure. I always want to caution the public health people when I talk to them. When you speak of this program and things like that, please be careful in your language, because you can actively support vaccinations, promote public health, and not demonize those that have said that they are vaccine injured. I think a lot of the vaccine hesitancy and misinformation, things that we're seeing today, is a result of that going back to the mid-2000s and the autism cases and things like that. And it's a dangerous thing because we have to be careful in how we speak about this. We can do both. Compensating vaccine-injured people and promoting public health and vaccinations can coexist. They did for 40 years, nearly 40 years. They're still doing it now. We are doing everything we can to constantly use the same language of vaccines are critically important public health tools, but they can also cause injuries in individuals. And I think we can do better on talking about both of those points. And that's what I would take away.
Thank you.
I'd only say I think Dr. Burgess and I are probably the only people in the room that went to school with children who had braces from polio and things like that. And in every little town, there was at least one person who was in an iron lung and so forth. This really matters. This matters tremendously. And the VICP is one part of an edifice that has been constructed over the past 70 or 80 years to ensure the public health through vaccination. And each part of it, the role of NIH in the development of vaccines, the role of the VICP in ensuring that when things go wrong, justice is done, and the role of the ACIP and others in determining which vaccines children should get and adults should get and when they should get them and so forth. Those are all part of a system, and all of the pieces have to remain in place for us not to see children with braces or people in iron lungs in the future.
Thank you so much. Thank you for joining us, and thank you so much to our panel.